Yeah, hold on a second. I just got to get something. Just let me play with this a second. Okay, and then let me just put this down. And let me join events. Good, you got a black tie on now. Is that knit or what? No, I see. Nice tie. Nice shirt too, I like that color. Alright, today we are doing, what, USMCA?
Yeah, so basically, can you turn the speakers off on your end?
Yeah,
please?
I turned it off. No echo on.
Yeah, I'm good.
Good.
Yeah, there was an echo at the beginning. So
Yeah.
basically, everyone, hello and welcome. Today we're going to skip introductions. We'll maybe save them for later because we are doing something with Ken and later on with me. This is something really exciting, but at the same time, we have to understand that Ken has limited time because he has other commitments. So we're going to go into the presentation. Presentation is very popular. I would say it's kind of like a hype, and the hype relates to the fact that it is Section 301 tariffs as well as other tariffs, and it also relates to the fact that the Trump tariffs have been challenged. So this means that everyone who can and who cannot writes about it and talks about it in the international trade community, and I think this is a topic which is very lively today. All right, Ken, can you hear me?
Yes, I can. I can see on the screen.
All right, so let me pull up my Adobe with your presentation on it, and let me see. Okay, so basically, what happened, as you know, we were contacted. There were a bunch of emails and everything related to question of Section 301 tariffs, and that topic was related to the recent challenge in the Court of International Trade. And the challenge was basically about Section 301 this list 3 and everything related to that. So I'll talk about the case, but before doing that, I think you have a good presentation to set up the background, because many people may not know what the Section 301 or 201, 232. Many of them got bombarded by all those notices, and at the end of the day, they have to pay 10% tariffs, 25% tariffs. So there was a lot of grievance. There was a lot of anxiety in the international trade community. So perhaps what you can do is you can lay down the foundation, where it came from, and how it all started. Mike, to you, Kenny.
Very good. Thank you, Yuri. Ladies and gentlemen, welcome. We're going to talk a little bit today about what's known as Trump's tariffs, sections 201, 232, and 301. And Yuri's going to help me move this from slide to slide. Just bear with us for a minute. We'll be able to get the show on the road. Okay, Nick. Okay. Let's talk a little bit about tariffs. You probably hear the word. Many of you in the audience know what it is. We're talking about taxes. Where does the word tariff comes from? Comes from a town in Spain. Actually, it was in North Africa called Tarifa, and eventually it became applied to what's known as taxes or import taxes. Right now, tariffs all over the world have been decreasing. Looks like in this age of deglobalization, however, tariffs may be increasing. We know in the United States has begun a trade war with the People's Republic of China, and the President of the United States, Donald J. Trump, has decided to, and this is a while ago, to apply a number of special tariffs or special taxes to goods coming in from the People's Republic of China. And that is in large part what this presentation is about. If you want to find out about tariff rates, where are you going to go? You should have familiarity with the Harmonized Tariff Schedule of the United States. That's that great big book. If you printed it out, it'd be about 16 pages. You can find it online. You can go to the Google search engine, type in Harmonized Tariff Schedule of the United States, and you can find out about different tariff rates, called rates of duty. When it comes to the U.S. Constitution, very much in news these days, especially in light of a Supreme Court justice who recently died and a possible appointment. Just realize that sometimes the government does things that people question, and a lot of people are questioning the applicability, the lawful application of these tariffs, these special tariffs, to goods coming into the United States. And it's supposed to be Congress. Congress is supposed to be the sole authority to regulate foreign commerce and therefore impose tariffs. Again, Congress has, just like with war powers, given up a lot of authority. It's delegated authority to the President of the United States. And the President of the United States has been modifying a lot in the way of tariffs. And you read about it. You go online every morning. Maybe you go to Google. You read a paper. You can find out about the imposition of these special tariffs. And they're causing problems. They're causing consternation. They're causing a lot of problems here in the United States. There are some companies that are actually folding because they can't pass along the costs of these tariffs to their customers.
Kenny, I think following up on your presentation, I just pulled up the U.S. Constitution and
Article 1, Section 8.
Yeah, comes to mind because I know in your presentation you say that Congress has a sole authority, and just to support that, there is that Section 8 clause.
Yeah. If you could stay with this for just a moment, Yuri, ladies and gentlemen, and Yuri, thank you. Thanks for bringing this up on the screen. There's some very interesting language here, and it has to do with the word shall. It's not may. It says the Congress shall. Okay, it has the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. Again, if you haven't read the United States Constitution, do so. It's not a great big document. It's a tremendously important document, but it's one that a lot of Americans don't refer to enough. And as a matter of fact, a lot of people are charging this current administration with not really paying attention to the plain language of the Constitution. where do these, again, why isn't Congress more involved? How does it happen that we have a president who's applying special tariffs to goods coming into the United States? How did this happen?
And we're talking about, of course, the third paragraph, the clause 3, if you will,
Right.
to regulate commerce with foreign nations,
Yeah.
and well, that is less relevant nowadays than before.
Yeah.
What about the? We have another one. I think section 10, clause 2. Duties. They also talk about duties, but it also kind of echoes that the consent of Congress is required.
Yes.
So that goes to the saying that basic premise that president has a sword and Congress has a purse.
Yeah,
It's the
I mean,
founding fathers
Congress
who
is
said.
supposed to be the big player in this. And then, ladies and gentlemen, any of you do exporting, you're cognizant of the fact that there are no export tariffs. Why? Because the U.S. Constitution prohibits that. About 5-6 years ago, I believe it was the state of Georgia. There was some, I could be wrong about the state, but there was some state that was tried to impose tariffs on exported goods. It fell through, and the federal courts basically said to the party being sued, go read the Constitution. And that's something that a lot of our representatives should do, pay more attention to the Constitution.
What about the
Right.
last point? The last bullet point says that, okay, even though Congress has the power to do that, but it often delegates this responsibility to folks such as folks in the Oval Office, right? Such as people like Donald Trump.
Yeah, it's happened. It's a number of presidents have done this. This has to do with the war powers, too. It's Congress is supposed to make decisions when it comes to declaring war, waging war. And yet, in the United States history, I think there's only been 5 lawful wars where Congress has actually declared war. So there's a lot of things that go on. There's a lot of activities that don't really take into account the Constitution or basically the Constitution in many ways, in my personal opinion, is disregarded. And we see this clearly in any number of international trade actions conducted by the U.S. government.
Well, I mean, in this particular case, since we're talking about the Trump tariffs, right?
Yes,
it's not
we are.
really a Trump tariff, because I just pulled up the exactly what you just mentioned in your last bullet point, which is Congress has delegated authority to the president, right? And
Yes.
this text is an official version of the Section 301 of the Tariff Act. Going back, let me see. Well, this is, I mean, it became codified in 75, but it was a Trade Act of 1974. So it's Trump maybe was around, but I don't think he was president at the time, right?
No. What happens, ladies and gentlemen, a lot of these tariff applications are taking place because the U.S. federal government, the executive branch of government, is claiming that they can rely on earlier laws, many of them related to national security, and that's how the government is basically hanging its hat on the imposition of these tariffs, these special tariffs.
All right. So, okay. So this official text just proves the bullet point that you had here about the delegation of authority, and it is precisely what Congress has done in the case of so-called Trump tariffs and Section 301 tariff in particular. Now, going to the next slide, I noticed that you mentioned that the way to do business, if you will, is to make sure that the action comes in the form of ad valorem tariff.
Yes, ad valorem, ladies and gentlemen, based on percentage. You think of a percentage. If you have $100 worth of imported goods, it's a 10% rate of duty. It's a 10% ad valorem rate of duty. That's the most common type of duty rate.
Okay, so if I may skip down, I mean, you have a lot of good stuff, but for the interest of time, I just want to get to the best parts of your presentation. So, if you allow me, Kenny, I want to go to page 8 of your slide, and it says that it pretty much lists 3 tariffs, and it's 201, 232, and 301. So this is pretty much the sword of Donald Trump, correct?
Yes, that's correct. And again, again, you can see with Section 201, again, there's a claim that, again, the idea is to temporarily protect domestic industries from goods coming into the United States. Many of you have heard of anti-dumping duties, countervailing duties. Actions sometimes are taken against importers because it's felt that after an investigation by the United States government that certain goods come into the United States at below what's known as fair market value. There's dumping. Anti-dumping has to do with collusion. It has to do with exporters getting together and colluding. The idea is that they want to take over market share in the United States. Countervailing duties come into play when there's government assistance overseas. The government is colluding or helping exporters when they send their goods to the United States. In both cases, it has to do with goods coming in below fair market value. So quite often, the United States government will impose special tariffs on goods that are being dumped in the United States. That's anti-dumping and countervailing. But now we're talking about these sections, Section 201, Section 232, and Section 301. And you can see the reasons for them. On the slide, you can see that the second bullet point, it says that these authorities allow the President to take action to temporarily protect domestic industries from a surge in unfairly traded imports. That's Section 201. And then there's to protect against threats to national security. That's a term that's not really ever been defined. That's Section 232. That can mean all kinds of things. And the third one is to respond to unfair trade practices by U.S. trading partners, and that's Section 301. These three different sections are in play right now. It all depends on where the goods are coming from and what type of goods are in play.
And most of the importing community, they really don't get into these details. They just see the bill, 10% bill or the 25% bill on their entry summary or otherwise through their broker invoice. So why would that be important? Those reasons, if you will, such as national security, unfair trade practices, or surge in unfairly traded imports. Is that something that everyone needs to know, or is it something that they just say, okay, this is just a bunch of...
Even those who are political junkies, I mean, it's difficult to see the future. I mean, not too many. I'm not great with a crystal ball. But, again, if you're going to be involved in international trade and importing, you want certainty, and that's something that you sometimes can get a great degree of, and sometimes you can't. Sometimes, when you least expect it, something is going to go wrong. And I've spoken to many importers, and that's what happened to them. They were caught off guard. They couldn't see the special tariff applications taking place. It just wasn't possible. It's hard to know what an administration is going to do. And many of these companies are between a rock and a hard place. They want to stay in business. They have many people working at these manufacturing companies here in the United States. God knows we need more of them. And many of the people working there are losing their jobs. And it's not just a particular individual loses a job. Their families get hurt. And sometimes they can't get the product that they're being imported. They can't get it here in the United States. It's just not available. And even if they can get, even if they're willing to pay the additional duties on the goods coming into the United States, they find it almost impossible to pass the cost along to consumers, especially these days. Everybody's strapped for cash, and a lot of companies are being hurt. Are they complaining? Yes, they are complaining. They complain to their representatives. Sometimes they may get action. They may get a letter back. They may actually get somebody from Congress to visit them or talk before a trade group and indicate that yes, the elected representative wants to do something as well. But you've got to be aware of the fact that trade wars do happen. I mean, right now it happens to be the People's Republic of China. I remember years ago the United States had a mini trade war. It's called the Banana Wars. It happened to be with a lot of European nations, and that was the time Bill Clinton was in office, and it all has to do with bananas. It had to do with, in particular, Chiquita bananas. Bananas are not really grown in the United States, but we had an American company, American corporation, that dealt in bananas, and it looked like the European countries did not want American bananas in their former colonies or in their countries. A lot of it has to do with taste. We have a Cavendish banana, And the Cavendish banana, the one that you're familiar with in the supermarkets, it's on its way out. It's been affected by something called rust. You may get another 4 or 5 years out of that banana. But people overseas in different parts of the world like different types of bananas. They're smaller, they're finger-like, and that's what they want. And again, they didn't want the banana, the American banana, or the so-called American banana. It's just an American corporation. And it led to a trade war. And there were all kinds of duties, imposed duties on things like vegetables, I think string beans coming in from Europe, and a lot of importers were just caught completely off guard. So trade wars are not usually beneficial to anybody. Yes, they can bring in money to a treasury, a governmental treasury, and that could be good in the short run. But it can also be bad because people figure out where to get the product, where to go elsewhere, and there's resentment. And trade can be a good thing, but it can also be very damaging. And we've seen from history what happens if trade wars are prolonged. Sometimes they can lead to military actions, and this is something we don't want. All right.
Kenny, but going back to the Trump tariffs, quote unquote,
Yeah.
we're talking about Section 201, 301, and 232. It may be the reasons again. They may be important because the justification gives you the certain position within the trade community of saying I can do certain things such as get duty drawback or not, or I'm eligible, for example, to get certain exclusion because this is not a national security concern, but rather this is something which is based on unfairness, let's say. So those terms they do acquire a meaning which translates to some kind of financial benefit at the end of the day, doesn't it?
Well, actually, you think about the term national security. What does that mean? We're talking about Section 232, I believe, the Trade Expansion Act of 1962. At the time, Congress, the government never considered this Section 232 in terms of trade. It was predicated upon national security, and that's a term that is never defined. I mean, when does the government ever define national security? Just like when it comes to importing, you're supposed to exercise, if you're an importer, something known as reasonable care. Where do you find reasonable care defined by U.S. Customs and Border Protection? You don't. And national security can mean all kinds of things. It's a weasel word. It's an ambiguous term.
Kenny, actually, there is an informed compliant publication about the reasonable care.
Yeah, I know, but it's never been defined. You can go to courts, and a court of law, as you know, and the judge can give you a definition. Jurors can do that. But Customs and Border Protection, if not, they'll give checklists and so on, but they've never defined.
Yeah, it's a term of art. That's what you're saying.
It's a term of art. Yes, many people say it's not just a term of art. It's a weasel. It's a weasel term of art. Yeah.
But if that was so, why wouldn't Trump would declare everything in national security? Why do they even bother with stuff like 232, 201, 301? Are they just being creative, or there may be a limit to national security? I mean, if you recall back to our law school days, remember the Youngstown Steel case, which had to do with it started by Eisenhower. Started by Truman, inherited by Eisenhower, but it had to do with Korean War apprehension. Basically, government taking over the steel and aluminum factories, and court said no. That's and they said, I think they claimed national security, and that didn't work out well. No?
Well, it all depends on who the judges are. As you know, Yuri, you've heard it in law school, you've heard it outside. What is the law? Many times people say the law is what the judge had for breakfast. Sometimes law is predicated upon the feelings, the prejudices, or the biases of certain judges. And we know what's going on today in terms of the Supreme Court. Okay, what's going to happen to it in the future? Is it going to be expanded? What's going to happen? Are they going to find a replacement for Ruth Bader Ginsburg right away? Is this going to happen right away within the next, say, 2 months? What's going to happen? But yes, sometimes it does make a difference who sits as judge.
All right.
We've seen this in U.S. history. We've seen the courts act a certain way during a certain period of time, and they've acted differently other periods of time. It all depends.
So it sounds like using different legal instruments is the way to make sure that you have better likelihood to achieve your objective, in other words.
Yeah, I mean, the courts are supposed to follow precedent. I mean, they're not going to if they have good reason not to. Sometimes there has to be a break from the past. But quite often, the courts maybe don't really want to handle certain issues, so they refuse to decide a case. And again, a lot of things come down to definition. If you want to argue with somebody, you should first be defining your terms. What is meant by a particular word, a particular term, a phrase, and so on. And it can leave the administration, the current one, with a lot of latitude. So it says it's predicating this Section 232 tariff upon what's known as national security. All right, I'd like to have somebody tell me what national security is.
Well,
what are the factors that make up national security?
I like this slide that you have up there, which kind of breaks it down in easier terms. If I'm looking, for example, at the Section 301 tariffs, I'm thinking China. And I'm not thinking other parts of the world. And if I'm thinking Section 201 and Section 232, I may think China, but not necessarily so. Because Section 201, for example, I can think Canada, right? Well,
yes.
Well, maybe not. But I think this, and let me move the slide further down. I noticed you have the solar cells over there. I recall
yes.
It was very popular at the time when Elon Musk, I think, was building his factories. Yes. Right. And Section 232, we're talking about steel and aluminum, of course, right?
Yes, that's exactly right. Big tariffs on that. Yes. And a lot of countries have been negatively affected. But you'll see from the slide, the third bullet point indicates that Argentina, Brazil, and South Korea are excluded from additional duties on steel, but are instead subject to quota allotments based on negotiated agreements. Again, quite often the U.S. government uses trade agreements to do what? To negotiate basically its national security interests. And we see this with the generalized system of preferences. You can read about that. Many developing countries are afforded special treatment by the United States Congress. And what's it predicated upon? Yes, the stage of development, but it depends in large part on whether or not they're going to listen to the United States government. Okay? So listen, right now, ladies and gentlemen, I'd like to continue with this, but I have to swear right now. But I want to thank you. Yuri, I'd like you to share the slideshow with them, and we're going to come back. We're going to have different, please notify us if you'd like us to handle a certain topic. We'd be more than happy to do so. Just let us know. And again, thanks for your
all right, Kenny. Thanks for your quick overview. You have some more amazing slides, but I'm gonna post it and I'm gonna make it available to the
okay, great. Yeah, please make it available to the audience. Ladies and gentlemen, thank you.
All right, Kenny. Take care. Good luck. Bye. All right. So, I think I got out of this basic groundwork presentation what I wanted to cover, because I wanted to set some background foundation, and I think that was kind of done. Now, as promised, I would like to go to something else. I would like to go to the, let me see, let me switch to the different mic now, since now Kenny is gone. Okay, so the hype. On September 10th, a lawsuit was filed in complaint in the form of complaint in the Court of International Trade, and I'm going to use the PDF presentation because I had the highlights, but let me provide the links to those who are watching in the chat, so that way we all can be on the same page. Just a second. So what does it mean by filing a lawsuit, and why is this important? All right, so okay, done. And those who will be watching later, you in the playback, you can find it in the description box. I'll be providing that a link as well. So going to the complaint itself, I think that it's very important to talk about the rationale of the complaint and why it was filed and what's going on behind it, because it did sound like that when the complaint was filed and a lot of folks in the community they were writing, they were talking about it, many of them were like, "Hey, I want a part of it too. I want a part of it too. I don't like to pay Section 301 duties." So many of them wanted to be a part of that, take part of it. But the problem, of course, was with publication about the timing. So what's going on with timing in this case, and what happens in general? So this case was filed on September 10th, and there were a lot of emails going out by various publications, various email alerts, saying, okay, the deadline is September, it was something like September 17th, and then some say, yeah, September 18th, Friday. Some say September 24th. So what's going on with that? So this is what we shall address at the beginning. But before we do that, let's take a look at the complaint itself and see what it is all about. I think starting from the stuff that are being asked would be very helpful, and this is at the very back of the complaint. So what are they asking court to do? And this has been filed in the Court of International Trade. So what they're asking court to do is they're asking to say, okay, so Section 301 tariffs, which relates to unfair trade practices, and as we saw from the slide presentation, concerns only People's Republic of China. And those tariffs came in various rollouts. They were part of initiations that took place for some time, starting in 2017, and they were used as a very important tool within the Trump administration to negotiate. So as the negotiations progressed, Section 301 tariffs also evolved, and from this came to be what's known as lists, and those lists are list 1, list 2, list 3, and there is list 4. It is as we shall see later, it is being published on the website of the United States Trade Representative, and they also all the relevant stuff are being provided. So the plaintiffs, in this case, the company that makes PVC or plastic tile, they have been affected by Section 3, by the list 3 tariffs, and they are coming to court and saying that those tariffs are not within the authority of president, and because of that, we ask this court to declare that the list 3 is in violation of the Trade Act. They also mention about, they talk about APA, as you can see, Administrative Procedures Act is there as well, and it talks about notice, but as you can see, it is the kind of like lurking in the background. But the Trade Act itself is really the big gorilla in the room, if you will. All right, so let's go to the reasoning behind why it is important to file, because a lot of the folks in the community, they say, oh, I want to be part of this, I have to be part of this, what's going on? So when the lawsuit was filed, it was filed and part of the filing, you have to find out whether you do have jurisdiction or not. And in this case, the jurisdiction was based on this particular line item. And this particular line item pretty much declared that you have, let me see, you have, you can sue the United States government. And so that's the subject matter jurisdiction. And there is a statute of limitations which says pretty much if you do it under that section, you have pretty much 2 years. The 2 year, according to some, began to run when, since we're talking about the list 3, it began to run from the publication of this notice in the bulletin, and it was published 2 years ago. So we're talking about 9/21, September 21st, 2018. So 2 years fast forward, that would be right about now. I've seen some people argue that because it will take place on September 24, 2000, it took the actual enforcement, the actual collection of duties. So for the Section 301 list 3, September 24th is the deadline. So we still have two days to file. Yet other folks argued something else. They argued that, listen, so we're talking about the 2 years from the date the injury, well, the cause of action accrues, right? So the cause of action accrues when you've been injured, right? So while this can be the injury, what if you haven't been engaged in imports? And if that's the case, then it's a problem because you have to make an importation, right? So the act of importation may start the 2 year statute of limitations. So in other words, there is no clear answer on this one, at least not the one that I've seen from the importing community, and this is something to keep in mind, that the deadline itself is subject to interpretation also. All right, so that's about the timing. Now, the next thing, we're gonna go into the case itself. So let's see who the plaintiffs are. Who are these folks who are saying that Trump did something illegal? All right, so this is a company. Well, actually, it's a group of companies. But if we fast forward, it's called HTMX Industries. And if you scroll down, there is a little description about them that it's a, as it says, it's a privately owned global luxury vinyl tile supplier. So we're talking about the Chapter 39 plastics over here. And it employs about 150 folks in the United States, supports more than 600 jobs according to the complaint, and generates more than 700 million in revenue generated. So when the tariff was imposed back in earlier this summer. Well, first of all, according to the complaint, they qualified for the exclusion, and after that, what they decide, the exclusion period ended, and now they have to pay tariffs. I think as of sometime this summer. So what's going on with that? What's going on with why are they saying that Trump was incorrect to exclude those tariffs to begin with? Well, it has to do with the statute itself. So as we saw a little bit earlier, when Ken was giving his speech, we saw that a lot of those things are kind of written in a broad type of way. So in the case of well, Ken talked about national security, but in the case of the 301, we're talking about the unfairness and unfair trade practices, and this is also pretty fluid. So when we speak about Section 301 tariffs, if some of you recall some of my lectures, some of my earlier lectures, the tariff itself is being codified, and it's being codified into the United States Code. And within the United States Code, the Section 301 is equivalent to the Title 19, Section 2411. And this is what it says. Actions by USTR, Mr. Lighthizer, right? So if the United States Trade Representative determines that the rights in the United States under any trade agreement are being denied, or, and this is the key, any policy practice of a foreign country violates or is inconsistent with the provisions or otherwise denies benefits to the United States under any trade agreement, or is unjustifiable and burdens or restricts United States commerce. So that last one is a key here because it's very broad. It's unjustifiable and burdens or restricts United States commerce. So if that is done, what Secretary of United States Trade Representative must do, they must make a finding. And after they do that finding, they make a publication, and after going through various administrative hoops, the tariffs are being imposed. So in this case, this is pretty much exactly what happened. And so that's Section 301. The finding, of course, are being kept time-wise. So in this case, we're talking about the Section 304, and the Section 304 is codified under the Title 19 USC 2414, and in this case, it gives, based on the procedure, it gives 12 months to the United States Trade Representative to make its finding. All right, so if and when the finding is made, assuming it is made within 12 months, let's say, and those people who watch the media, they probably are aware about this because the negotiation talks, they sometimes roll out with a full force, sometimes they reach a tipping point, then they come down, then they go back up, and that has been like a roller coaster ride for the past 3 years or so. So there is this provision according, again, according to the United States Trade Representative, they can use, but according to the complaint, it has been used incorrectly. They can modify. They can do they can modify based on the authority provided under Section 307 or section 2417 within the Title 19. And what that says, oh, let me see. So this is what we're talking about. Again, very broad language. So trade representative can modify if burden or restriction on the United States commerce of the denial of the rights, acts, or policies or practices has increased or decreased. So, in other words, you have a situation where there was an agreement reached, and then China retaliated. And because China retaliated, this is considered to be increase or decrease in the burden. And because it is considered to be increase or decrease in the burden, that qualifies for the modification clause, and that exactly will happen throughout various Trump and United States trade representative policies. Okay, so I think now we are good to go to the timeline, which I have up on the board. And this timeline says the following. So we have August 18th, 2017. So, and we're talking about the investigation which has been Section 301 was initiated, right? So the rubric was this: unreasonable or discriminatory and burden or restrict U.S. commerce. And then there was a clarification that this means it doesn't necessarily mean it's illegal, but it does mean that it is unfair, it is inequitable. All right. And when the United States Trade Representative performed its investigation, the focus was on the technology transfer, intellectual property, and let me see, I have it somewhere over here. Yes, right here. So finding of facts. So if you look at the finding of facts, it is based on unfair technology. It is based on unreasonable practices that discriminate against Chinese business and non-Chinese business, and it talks about the investment policies. It talks about the financial policies. It talks about the investment within the China and outside of China. It talks about even the monopoly and anti-monopoly laws, the talent acquisition, and many other things. So we're talking about the 182-page document which encompasses a lot of things. Under that rubric, of course, broadly speaking, the focus is tax transfer, IP, and innovation. So when the complaint was filed, the focus was, all right, so Mr. Trump, you have filed and done your investigation. You did it within the due time. So list 1 and list 2 are okay. But the problem is not with list 1 and with list 2, but with list 3. Because what you have is the rationale for the section, the list 3 tariffs are not related to the finding, but are related to the fact that China retaliated against Donald Trump list 1 and list 2 tariffs, which comes to about $50 billion. So, because China retaliated, and Donald Trump and the United States Trade Representative responded, here is a punchline. Defendants, and we're talking about the Trade Representative and Donald Trump, wildly expanded the scope of the tariffs imposed under the Section 301 of the Trade Act to cover imports worth more than 500 billion. 10 times the amount. So original amount was something like 34 billion list 1 and 16 billion, so $50 billion. So we're talking about 500 billion, which is 10 times the amount deemed commensurate according to the original investigation. So that's that's the thing. So when Donald Trump made investigation on I mean, the United States Trade Representative made the finding. That finding kind of concerned that $50 billion amount within that rubric of the tech transfers, IP, and innovation. Now we're not talking about tech transfers, IP, innovation. We're talking about the kind of like the trade war rubric where you throwing punches and someone is throwing punches back you, and this is all about the escalation. And this is something which plaintiffs argue is not which was the Tariff Act designed to do. Now, going back to the timeline, so we have that report that we just talked about coming out within that 12-month period. So it comes out on the March 22nd, 2018 from the original timeline. Fast forwarded several months, and you have the tariffs under the section under the list 1 coming into force and under the list 2 coming into force, right? But this we're talking about summer 2018. Next thing that you have is you have the July 17th. That was when the escalation took place with Donald Trump, and under that escalation, the list 3 investigation took place. Of course, that 12 months statutory deadline for investigation expires on August 18th, so that took place before that. But within that list 3 rubric, what happened is another proposal of $500 billion, which took place, and the administration was very much explicit about it. It was saying, "Look, this is about the retaliation. This is about retaliation because they had a nerve to question our policies, and this is not right." So, and this is precisely the argument. So how did the United States Trade Representative justify such retaliation? How did they explain that this was a proper thing to do? Well, we can find it in the July 17, 2018 notice. That was that notice that remember when we went in and talked about right there, July 17th, this one, when the list 3 was proposed. So the proposal itself, it came through the Federal Register notice. And the Federal Register notice, if you look at the page 2, right there, the first column, section. So there is no question about section 301. That's kind of established. But here's what United States Trade Representative says with respect to his ability to impose additional tariffs. Section 307 of the Trade Act provides that the trade representative may modify or terminate any action subject to the specific direction, if any, of the President, and that was done, we know this, with respect to such action that is being taken under Section 301, which it is, if such action is being taken under Section 301B, and by Section 301B we're talking about this one, and is of this title, and is no longer appropriate. In light of China's response to the, and here's that explicit, China responded, so we must act. Okay, so that particular section, section 307, right here, is gives the ability to modify. And United States Trade Representative, as we saw in the Federal Register, is pretty explicit about the modification. So it is this stuff that are being played out in court right now. It's whether or not, in other words, and this is the main issue. There were ancillary issues such as the Administrative Procedures Act, but the major interesting issue is whether or not the Section 307 was properly applied, which allows the United States Trade Representative to modify its finding, because those findings and the actual enforcement took place outside of that deadline of investigation. So in other words, the United States Trade Representative can issue another investigation, that's fine. But in this case, it didn't, and it improperly applied Section 307. So that's the argument. Whether it will succeed or not, we will. It remains to see. The biggest problem that I find with this argument is the very broad scope of the language. As you can see, it's very broadly written. And if you look at the complaint, I'm going to pull it up right now. If you go towards the end, by the way, the complaint itself is a very good summary of the imposition of Section 301 duties in the past 3 years. But what I also wanted to point out is the application of, let me see. So it's this one is a relief, is an application of this particular section. So we're talking about the count 1, right? So the plaintiffs say, okay, they may impose tariffs when it's unreasonable and discriminatory, right? But in case of list 3 and list 3 only, it is inappropriate, because it relates to retaliation, and retaliation is not within this particular framework. Also, they talk about the timeline. So the action giving rise to list 3 occurred in September 2018, and August 2018 was the deadline for that 12-month period. So we're talking about the time frame, which is procedural, but it's still out there. And last but not least, the section 307, which is which is going to be very hot within this particular lawsuit. Yes, the plaintiffs say it does authorize trade representative to modify and terminate, which is the language that the trade representative used, but it does not authorize, and here's the key, to increase tariff actions that are no longer appropriate, but rather only to delay, taper, or terminate such actions. So, in other words, modify, terminate, and increase within this context are mutually exclusive concepts. So this is what the argument is. Again, the language is extremely broad. The timing also is interesting. We know that the elections are coming up very soon. So and by the case usually takes more time to go through. So it will go past the election. So maybe just maybe that may have some effect on the course of litigation. But we will remain and see. Otherwise, that trade war rubric came from the political branches of the government into the judicial branch of the government, as we just saw. All right, so I think we're good for today. This covers the section 301 tariffs. We talked a little bit about the section 201 and 232. I'll make the various links posted after the stream is over. And thank you for coming over, and we'll see you next week. Bye.